good night. This is U.S. Immigration Attorney Sharifa Tharpe. I am here live to take your U.S. immigration related questions. So go ahead and put your questions in the comments so that I may answer your questions. Now, I have a great topic for you to hear tonight, and I'm also hoping to get your immigration questions. So the first is, can you still get permanent residence if you have something in your background that has rendered you inadmissible? Would you still be able to get permanent residence? And the answer is very well, it may be possible. Now this is a more complex topic, and so I'm going to talk about it from a very, very general perspective. And so that is where you definitely have to get personal legal advice to determine whether you can qualify for any kind of forgiveness or waivers, as we like to call it in immigration, if you would like to still get permanent residence. And sometimes, in some cases, you can even still be here and apply for this form of forgiveness and still go through adjustment of status. Now, when you are rendered inadmissible, that means that something in your background and something in your background happened that has made you ineligible to come to the United States or to get permanent residence. When that happens, sometimes it does not mean that a solution is impossible or that your ability to get permanent residence is impossible. In some cases, it is definitely something that may not be possible. However, once you are inadmissible, the next thing you need to determine is, do you qualify for a waiver? And so I'm going to touch on that today. Some ways that you are still able to get a waiver if you have been rendered inadmissible. This applies if you're outside of the United States, and yes, in some cases, if you are in the United States. Now, the first and foremost one is your criminal issues. So if you have any criminal issues, when it comes on to evaluating criminal issues, it is very complex just because it really comes down to the facts in your case and whether the facts of the offense that was committed or the offense to which you pled guilty to or you are found guilty of presents as a crime involving moral turpitude. If there are multiple crimes involving moral turpitude, then that could render you inadmissible. Also, if you have been convicted of 2 or more crimes with a total sentence of 5 years imprisonment, then this could also render you inadmissible. And then, of course, you know that if you have been in the United States without status and then you leave the United States, then at that point, unless you are forgiven through a waiver, you can become inadmissible. In the case that you have now, in one that I do want to talk about that is pretty common is our drug offenses, particularly where you are selling the drugs, distributing the drugs. In that case, it could render you inadmissible. And that one only has a very, very narrow waiver. So if you have had a previous drug offense, you are found to be a drug trafficker. This means you are selling, you are distributing drugs. Then there is no waiver for this unless the offense that you were convicted for was for one single charge of marijuana, and it has to be a very, very, very small amount of marijuana. So that is where if you have had any kinds of convictions related to drugs, you definitely need to make sure that you get your case thoroughly evaluated to determine whether you could fit within this very, very narrow process to get forgiveness for that. Thanks for sharing the live. I appreciate it. I'm also here to answer your immigration questions. So I need you to work on something for me. So Renorta, if you need me to work on something, the first thing we need to do is to determine what you qualify for, and then you can call my number and then schedule a consultation. My number is all over my website. It is also on videos. If you go to the link in my bio, you're able to, it will take you to the website where you'll see the number, a contact form, and then also the online chat. So 3 different ways to get in touch where you can get that appointment scheduled. So yes, Gehabi, I am, and I can assist you with employment based permanent resident cases. But first I have to vet your situation, make sure that you qualify as the employer. And if you are the employee, then make sure that you and your employer are fully involved. Because when it comes on to employment based, there are different types of employment based. There's the extraordinary ability. There's the national interest waiver. There is an EB, and then in other cases, the EB1, the EB2, the EB3, then the professional, the unskilled. And so the professional, the unskilled, and so under the EB3. So whether you can qualify for one of these is going to depend on the facts in your particular case, and whether you are ready to get involved in your process. So go ahead and schedule a consultation. Hi there, Jhine274. It's nice to see you. Go ahead, put your questions in the comments. Tonight, I am just talking about, okay, so I see additional questions here. How soon after the biometrics is done, you're likely to get a work permit? So that is not something I would know or anyone else would know, just because it's all over the place and it is really not down to a scientific, accurate calculation as to when you're going to get the work permit after you get fingerprinted. However, you can always check the processing times at that and how long they're taking to process the I-765 at the service center that's processing your case, and you'll get an idea of the range of time they're taking, and you'll be able to get an idea of when you could expect yours. Can I know for citizenship exam, we need a 3-year marriage or 3 years needed complete in the green card? So both. So Jay Hind, if you are applying based on the marriage to your U.S. citizen spouse, you're going to have to show that you have been married to your spouse for 3 years and that you've had permanent residence for 3 years. Hey, how do I start the process of what to bring my spouse to the U.S.? So it is quite the process. It's about 18 to 24 months, and it really depends on whether your spouse is outside of the United States or in the United States. It sounds like they're outside of the United States. If they're outside of the United States, first there's a process of applying for the petition, and then after you have submitted your petition, then you're going to wait for a decision on it. Then when the decision comes and it's an approval, it will go to the National Visa Center. From there, I usually work with the National Visa Center to make sure that my client's application and all the required documentation is completed. And then from there, it goes to the interview. Don't underestimate this process. Oh, it's Jax. You want to make sure you get legal advice and representation through your process. Is that the same for the fiance visa? So the fiance visa is slightly different. So first of all, the fiance visa is a temporary visa. The spouse visa is for permanent residence. The fiance visa would be for your fiance to come for 90 days in order to get married. Now, the time period is taking long. So it's taking over a year and a half to even get the appointment, but you still do have to file the petition see that it's approved first, then it's going to go to the National Visa Center, then you're going to have to submit all the required documentation. And then from there, once you have done that at the National Visa Center, it's going to go to the embassy for the interview. So now this is one, I know it can be a struggle to determine which one would be best for you. And it really comes down to your preferences. I don't know what your circumstances are, so I wouldn't be able to help you in this live to make that decision. But if you schedule a consultation, we can talk more about what your circumstances are and then determine how to move forward. And thanks for the compliment. Oh, it's Jax. All right, so I am both on TikTok and I'm on YouTube. I am the same name on YouTube. The name of the channel on YouTube is The Immigration Attorney. You can go to, I mean, you're already here, but if you're on YouTube, you are listening or you're watching, go ahead, put your questions in the comments because I am here to answer your questions. So why not put your questions in the comments? I thought I would come with a particular topic myself, and that is to let you know that if you have been rendered inadmissible, whether you're outside of the United States or you are in the United States, there still may be a way to apply for permanent residence and get forgiveness through usually a waiver for whatever is rendering you to be inadmissible. That may be a criminal issue. That may be unlawful presence. That may be a misrepresentation even, or fraud. Now, with these, most of these, what you usually is required is going to differ from case to case. For example, with a criminal issue, if you are seeking, there are two ways to seek forgiveness, just based on how long ago did the offense take place. If it was more than 15 years that the offense took place, then you would just have to show that you are now rehabilitated and allowing you back into the country or allowing you to have permanent residence or your status in the US is not going to be against the public interest. However, if it has not been 15 years since the offense happened, in that case, you're going to need a qualifying relative. And the qualifying relative is going to have to be a U.S. citizen or legal permanent resident, spouse, parent, or U.S. citizen, son or daughter. And they will have to be experiencing extreme hardship if you don't get the permanent residence. Now, usually with a lot of these waivers, they do require the showing of extreme hardship by a qualifying relative. So when it comes on to unlawful presence, for example, that means that you overstayed and you're here and you need forgiveness to be able to complete your process. You must show that you're a U.S. citizen, you have a U.S. citizen or legal permanent resident spouse or parent who will experience extreme hardship without you. Now, with misrepresentation, that comes with a lifetime bar. And so if you must have a qualifying relative to be able to get this forgiveness. But I'm here to tell you that it is possible. So if you've been told that there's no way to come back to the United States, if there's no way to come back to the United States because you're inadmissible, there may be a way. And that may be a way through a qualifying relative and for by applying for a waiver if that waiver is available. For misrepresentation or fraud. Hi there, Dark Horse 45. It's so nice to see you. Thanks, and thank you so much. Happy holidays to you too. Now, if you have been charged with immigration misrepresentation or fraud, I like to say this. You will probably know if you've been charged with misrepresentation or fraud. An officer will usually scribble it all over your passport or your visa, or you'll get a decision letter with that immigration charge in there. And once you have misrepresentation or fraud on your record, then you will need to make sure that you get a waiver in order to get permanent residence. In order to qualify for this waiver, you will need to have a U.S. citizen or legal permanent resident, spouse or parent who will experience extreme hardship if you don't get this permanent residence. What can be done to avoid the green card from being revoked? So, Gehabi, it's going to depend on the circumstances involved. There are many different ways, many different strategies, many different approaches, but it really comes down to what is going on in your case. Why is it being revoked in the first place? Is it true? Is there a misunderstanding? Is there a defense? And so, Gehabi, schedule a consultation if this is something you're going through, or if there is someone else that you know that this is happening to, they should get legal representation. And I am here to assist with that. So make sure you go ahead and pass this information along. And go ahead, share this live. Share this information. But keep in mind that the information I'm giving you tonight is not personal legal advice. It is general information. And so you still want to schedule a personal consultation to get the information you need to proceed in your particular case. All right, so that is going to be it for me tonight. I will be back tomorrow. I try to get on here around 9 p.m. Eastern time, both on YouTube and on TikTok. Now, where am I going now? I am going over to Instagram. I do a live at around 9:30, and as you can see, it's 9:36 now. So I am running late, but I do a live on Instagram. So if you are not finished, you want to ask more questions, you can just hop on over there with me and ask those questions. I am the same name on Instagram as I am here, The Immigration Attorney. So it's pretty easy. Once you see the name of the channel on YouTube, the name of the profile on Instagram, on TikTok, then you will know the Instagram name. It's The Immigration Attorney. Go over there and join me. On TikTok, it's very easy to do that. There is a button on the profile page that allows you to click on it, and it takes you directly to my Instagram page. I'm going to be there answering questions, same as here. So in the meantime, I will be on, and I will be on throughout the holidays. So you'll see me making appearances. So look out for me, 9 p.m. Eastern time every night, or most nights. You know, there are going to be some nights where I wouldn't be able to make it, but most nights I am going to be here to answer those questions. So put your questions in the comments. Let's see, what's the easiest way to marry a foreign citizen? So it's going to depend. If your foreign citizen has their visa to come to the US, that's an option. If, you know, it just depends on your circumstances. Two people can make a decision as to where they want to get married if they're allowed to do that. And as long as the marriage is valid, it can be used for immigration purposes. So that is really up to you. Hello, my dear, and can an employer sponsor an illegal? So whether an employer, I thank you for this question. An employer can sponsor someone who is here without status under very, very limited circumstances. So the one situation where generally an employer has to apply for someone who has current status. But in a case where this employer is looking to recruit, they found someone that they want to sponsor, but they're here undocumented in the United States. This undocumented immigrant cannot qualify unless they get forgiveness through a waiver for the overstay. They'll have to finish out their process at the embassy abroad. And they would have to still have qualifying relatives. So they would have to have a U.S. Citizen or legal permanent resident spouse or parent who will experience extreme hardship in order to get approved for this waiver so they can finish the employment sponsorship. So as you can see, there are multiple steps, definitely multiple requirements. So not only do they have to have the employer, but they still have to have qualifying relatives to fix their status. So how much is it? So Cupcake USA, I don't know what you're asking, if you're asking about an immigration file, but the cost of my consultation is $150 for up to an hour. I like to say it is well worth it because you walk out of this consultation with legal advice. This is not something where you're going to sit down and you're not going to get value. You get legal advice, and you do get enough legal advice to understand your process, understand your options, avoid mistakes, and you can walk out with me as your attorney. So it is a very valuable start to a good thing. Do they deport straight from Stokes interview if you fail? So usually not. Cupcake USA 95. However, if you are having issues, now is the time to make sure you get representation so that it doesn't get any worse than, or you can try to not make it get any worse than it already is when it comes to the Stokes interview. So my mom is a green card holder, and she sponsored her kid. How many years will it take to get through? So if the child is under 21 and unmarried, you're looking at 18 to 24 months. If they're over 21 and over and they're unmarried, it's taking 5 to 6 years. And green card holders can't sponsor their married children. Dark Horse 45 says it's worth it. The consultation is worth it. I can tell you. Thanks so much, Dark Horse 45. Thanks so much for the support. I always appreciate that. Cupcake USA 95, you are welcome. So I'm gonna head on over to Instagram now. Just hop on over there and let us talk about, let's talk some more. If not, we'll talk tomorrow or talk in a consultation. There is a scheduling coordinator who's available up until 11 p.m. tonight to take your call. It's right before the holidays, so get on my schedule. Get a head start to the new year before my schedule fills up. All right, have an awesome night, and I will be seeing you throughout the holidays.